Thank you for that introduction. And firstly, just thank the sponsors and the hosts for who without this conference would not be possible. So today I'm going to be talking about this new ISO standard 31700, which is all about privacy by design. I'll also obviously be talking about privacy by design, what that is, and how that can be employed within a software development lifecycle. If I have time, I'm going to give an example, but there is a lot to get through. So 31700 is a standard that fits into the risk family of standards with ISO. And as you can see, it's providing requirements for, it states consumer goods and services. I think really it can be used for any service that collects, stores, or processes personal information. And whilst we're on the subject of terms, in New Zealand, the Privacy Act defines the term personal information. That's also a term that's used in Australia. You will hear the term PII used lots. That's an American term. So if you want to be American, use that. In Europe, they use the term personal data. That's in the GDPR. So I'll be using the term personal information, but other terms may pop up. So what is privacy by design? It's a set of principles that were developed in the 1990s by Anne Kavakian when she was the Information and Privacy Commissioner for Ontario, Canada. And they are principles. She is a psychologist by training, not a lawyer. And so they're principles, they're kind of not fluffy, but they're not terribly well defined. And over the years, different people have provided different explanations about what each of those principles actually mean. And we'll see a number of different interpretations as we go through. I'm going to go through and just quickly show you some of the interpretations that actually come from the digital.gov.nz team. I think these are probably some of the most concise explanations of the principles that I've seen. And the first one really is probably familiar to a lot of you in terms of let's move it left. So a lot of you will have been engaged in trying to get security to move left. And this is essentially stating the same for privacy. If you don't consider it up front, you're going to be in a world, probably a potential world of pain going forward if you have to go back and retrofit some of the functionality. And I'm sure that a number of you have experienced that with security issues and trying to get those resolved. Often those things will just sit in a backlog for years and years. The second one really is about understanding what the regulations or the law applies to you. In New Zealand, it's the Privacy Act 2020. Other jurisdictions have other requirements, and they may be applicable to you depending on where you sell your products and services. Yeah, this one I think is fairly self-explanatory. Full functionality, this really speaks to, it doesn't have to be a privacy or a good product. It can be both, and it should be both. Likewise, well, this one should be familiar to all of the security practitioners in the room. This is simply stating that the personal information should be secure from end to end, from when you collect it, store it, use it, and ultimately to when you destroy it. This is, again, really quite self-explanatory. If you're going to collect data, you should let the consumers or the persons, the data subjects, know that the data is being collected and understand what that is. This one, I guess, is vaguely topical in that we don't have any of these signs in New Zealand, but perhaps we should. And then this is probably the most important one, really. This speaks to why is privacy important. It's because it's about people and harms. The harms that are caused by privacy breaches affect real people, and so people should be at the heart of how we design for privacy and why we do that. The standard ISO 31700 provides its own definition of what privacy by design is, and I'll let you read it. And as you can see, it's quite limited compared to the principles in many ways. It's really speaking about the first principle, I guess, and it's picking up on some of the other principles, but quite concise. In terms of how privacy by design and the law intersect, in New Zealand we have the Privacy Act 2020. In section 22 there are the information privacy principles. Number 5 relates to the security of personal information. It really doesn't speak about privacy by design, so it's a bit of a long bow to say that it applies, or that privacy by design is mandated by the Act. That's not the case with the GDPR, which is the regulations that apply to the EU and currently to the UK as well. There is a very specific article, number 25, which calls out the need for privacy by design to be employed in systems that store, process, and process personal information. And that has a relationship with Article 32, which is about what security controls are appropriate to protect the personal information. If you're interested in other jurisdictions and what may apply in relations to privacy by design, the IAPP have a mapping which shows the number of jurisdictions. Obviously, that's going to be a work in progress. You know, the US in particular, there are lots of different states. So check if you really need to understand a particular jurisdiction. Obviously, check with a lawyer. And so we come to Article 25. I'm not going to drill into this, but I think what's interesting is you have the principles, which are relative, you know, that they are just principles. Then you have a bit more of a flesh in terms of the ISO 31700, but the specifics in Article 25 are getting more and more detailed. I mean, it's not PCI DSS, but it's starting to talk about specific controls, about specific methodologies. And the reason I think it's important to understand what the GDPR requires is because although we are in New Zealand, a lot of us are developing products and services that will be sold into Europe. You certainly would hope. And even if you're not developing a system that you're directly selling into consumers in the EU, you may be developing a system that processes personal data of another companies. So, and that would mean that you were a processor, and that these provisions would apply. So I think you can treat it kind of like as the high watermark, and I think you should treat it as an aspirational goal. If you're not selling into the EU, and if you are selling into the EU, then you really need to have a very good understanding of what this means to you, because it can get quite expensive. And I've just put this up as a compare and contrast. So there are a number of offences in the Privacy Act 2020, and you can get fined a maximum of $10,000. You're probably not going to get a lawyer out of bed for $10,000, so that's not a lot of money. You can get damages against you under the Privacy Act, and there was an interesting case of an employee, their employer, a cake that had some quite interesting icing on it, and it was found that there was an interference of privacy, and they were awarded $168,000. But in comparison, if we look at the fines that are available under the EU, they are considerably more. So you're looking at 20 million euro, or 4% of your total worldwide revenue as a potential fine. So that's pretty meaty. In terms of actual fines, this is just a random example that I pulled from the UK. A company called Interserve. They had a data breach where employee data went missing. Well, it didn't go missing. An attacker got hold of the internal information. Their systems were offline for a number of weeks as well. They were fined over almost £4.5 million. The cause of that was just general bad security. But one thing I think that's interesting that they pointed out is that Interserve were not doing what they said they were going to do. They had policy and procedures up the wazoo, but they simply weren't using those. So I think that's interesting. If you are going to have policy and procedure, make sure that it actually is what you're doing rather than just a fairy tale. More specifically, this is an actual infringement for an organisation that did not employ privacy by design. So this is the case where there was kind of a Find My Friends feature that was implemented by Facebook. I think it was in the Messenger, I'm not sure. But anyway, it didn't have great controls, so people effectively scraped it. And they scraped approximately 533 million Facebook users. So the Irish Data Protection Commission found that Facebook had infringed Article 25, the article that speaks about privacy by design. And as you can see, that was quite a meaty fine they got handed. So that's up into the territory where they're looking at the annual revenue of Facebook and using that as a basis for the fine. So you can clearly see that, I mean, that's quite an egregious case, 500 million people, but it shows that the EU are very serious about privacy and about privacy by design. And in this case, it's worth having a look if you're interested. But they speak about how they should have put controls in place to stop the scraping. And there's a bit of back and forth between Facebook and the Commissioner on that point. But yeah, ultimately the Commissioner found that they should have put technical controls in place to have stopped that. And if they had performed privacy by design, they would have put those controls in place and the breach would not have occurred. So, back to ISO 31700. It's essentially a framework, and for those who's familiar with ISO 27000, okay, poor buggers. So you'll know that generally there's a sort of a starting section which talks about governance, it talks about responsibilities, about ensuring people are educated, and this standard is no different, and that's covered in the management component of the framework. Then it moves on into the risks, or the risk assessment, and I guess this is at the guts of the standard. It's ISO 31700, so it's in that risk family of standards. So this is about identifying risks to privacy and assessing those risks, understanding how, what the priority of those risks are, and there's a variety of methods to do that. And once you have identified those risks, obviously the next thing one should do is look at controls that can be used to help mitigate the risks. And there's a variety of sections that go through the design of the controls, how one would develop those and deploy them, including testing of the controls during development, then the operation of those controls, and finally looking at ensuring that those controls remain in place and are working as they should do with verification of the controls. The standard also talks about a couple of matters which are probably more dealt with in a privacy management context. One is consumer information, and that's where you're telling the people who you're collecting the data from what data you're collecting and why, and really that's probably best left to lawyers to do, although in association with product managers. And the other aspect that it talks about is breach. So it talks about the need to ensure that there's breach notification, breach response processes in place and appropriate breach communication ready to roll for your consumers. So that's probably something that's best, again, a conversation with lawyers, definitely on the notification side of things. And if you have an incident response procedure, then you probably just need to have add that in there. If you don't have an incident response procedure, then you should probably start looking at creating one. So in terms of how the authors of the standard see it operating, they see it in the middle there, so very much the risk assessment, implement controls, rinse and repeat. So, and that works obviously in a sort of a waterfall-y process where you've got new revisions, or can work in an agile context where you may have various epics, new product features, and then at the end the provisions for ensuring that you delete the data. I've kind of reframed it, and I think probably there's not. I think they could highlight the need to understand the business requirements a bit more in the standard. I think that's really crucial. You need to have a very clear understanding of what the product is and what the product is going to do. And that needs to be defined and communicated, shared and communicated and agreed upon. Because I think one of the issues when you get into collecting data is that you have people who will say things like, data is the new gold. And well, it may be, but maybe we're only, trying to collect, the number plates of the cars that are in our car park for a 30-minute period. We don't need to create a surveillance system. So having a really defined definition of your product is super important. From that, you can then start looking at what data flows will be required or may be required to implement that. And that might be an iterative process, because you might start off thinking you need lots, and then hopefully you'll be able to pare that back down. And from those data flows, you begin to understand what sort of risks that you have to privacy, design the controls, develop, implement, and operate. Something I haven't mentioned up until now is that the standard actually comes in 2 documents, which means that there's 2 documents to purchase. The second document is sort of explanatory material. They have chosen to select a use case method that is based on some IEC standard. I think you could probably create your own, basically. I think data flow diagrams are probably a lot more useful than sequence diagrams, and probably just use case diagrams for defining your functionality would be great. So I would not rush out and purchase this document, is what I'm saying. I would use, I think, I would use what works, and yeah, I mean, especially given that this is likely to be highly contextual in terms of what diagramming and documentation approaches that you have within your organization anyway. So in terms of risk, I think there's really 2 categories of risk that we need to think about. The first, which is the most important, is the risk to people. So this is we're talking about the harms that could affect actual people through a data breach or other issues with privacy. So they include obviously emotional distress, financial issues, and physical harm. Unfortunately, there's some nasty people out there, people who will stalk other people. So actual physical harm can occur. The other aspect, which I think probably a lot of organizations will focus on more, is actually what is the harm to them if they have a privacy breach. And whilst that is obviously key to understand, especially if you're operating in the EU, I think you need to have a mixture of the 2 when you're performing these calculus on what you're going to spend on mitigating risks. As we pointed out, you can get fines and damages. There's also the cost of responding to a breach, which is not insignificant as well. So for the approach to actually assessing privacy risks, the standard calls out a few options. The NIST privacy risk assessment methodology, otherwise known as PRAM, I think is quite a good framework, or which you could use as a starting point for managing the risk. So identifying the risk and then classifying it in terms of its likelihood and its impact. LINRUM is a privacy threat modeling methodology, and it apparently fits quite well with STRIDE. So if you're doing threat modeling, that would be some additional dimensions to think about. The French organisation have a privacy impact assessment document. It's worth noting that in New Zealand we have the Office of the Privacy Commissioner has a PIA toolkit. I personally don't think it is granular enough in terms of the risk identification, but there are a number of PIAs that are out there, and they can be used for this process. Although I think having a more detailed process like the NIST PRAM methodology is probably appropriate. These are the threats that LINRUM looks at. I'm not going to go through them. I'll just point out, though, that they actually put in their non-compliance as one, so they're already mixing the risk to the person and the risk to the organisation. In terms of creating the privacy controls, Article 32 is, I think, quite interesting in that it's saying look at the context essentially, look at the risk, look at how much data you've got stored, look at what that type of data is, and then implement something that's appropriate to protect the risk. So yeah, where are we? Oh. Sorry, my slides have jumped around a wee bit. So in terms of privacy controls, I'm just going to run through some which I think can be really useful. The first one is one which doesn't get mentioned probably enough, which is just separating your system into subsystems so that you can provide finer-grained access control and so that the data isn't available to other people. If you've done the PCIs, segregation of your environment is key. You can think of the same thing within a privacy context. Data reduction, super important. If you don't need it, don't collect it. So that relates to the breadth of the data that you're collecting and also the depth of the data that you're storing. You've probably seen the latitude breach in Australia. That's an example where they've kept information that they shouldn't have kept for too long, and now they're in a world of pain. Also, what data needs to be shared. Again, there's a case that's just come up recently where NZTA were passing information to Wellington Council about crashes. They, in terms of the fields that they supplied, they provided way too many fields, including some really sensitive information. So only share what you need. Encryption is going to be key. You want that's a key way of ensuring the confidentiality should an attacker get hold of your database. Obviously, it needs to be application level. Just having disk encryption or transparent data encryption on your database files is useless, generally speaking. So make sure it's at application level. And make sure you don't have your keys stored in a config file or in the code. We've got lots of key management systems in the cloud that's available, or if you're on-prem, there are other means of securely storing keys. Access control, again, really important. If you've got one service that needs to write personal information to a system and another one which needs to read it, have two separate roles. Don't just have a generic service account that has the both of them there. Tokenization, that's a way of taking an ID, such as a license plate, and turning it into another ID, which is not the original. Sometimes you'll need one way, where perhaps if you're sharing that information with another organization, you don't need to reverse the tokenization. Often you'll need to reverse the tokenization. So you might write a token and then need to convert that later in a process. If you're storing an absolute metric ton of information, then obviously just tokenizing things does not prevent re-identification from occurring. So logging, reviewing, and alerting. So if you've got users who have access to highly sensitive information, you want to ensure that you're logging access to that, reviewing it, and alerting on that. So yeah, you need to have a handle on that. And you can have specific application level application controls. So an example of that might be if you did have really sensitive information so maybe a health system, and you have well-known people who have their details in that system, you might mark those well-known people, and you might require a two-step phase to gain access to that information. So, perhaps if I'm a CSR, I need to make a specific request to a line manager who then responds to that before I get access to that information. So, unfortunately, I don't have time to go into my example domain. So which is a shame, but I may try and put some of the details up online. So with that, I thank you. I guess we've got a minute for a question.
Do we have any questions?
Does the ISO standard that you were talking about take into consideration combinable data sets?
Sorry, I didn't catch the last bit.
Does the ISO standard 31700, does it take into consideration things like combinable data sets in how safe your data is from identification?
No, it's really like a lot of ISO standards. It's very high level. It really, you know, it's not a PCI DSS. It refers to other standards. It refers to other methodologies. It's all about the context. So no.
Any other questions?
So talking about the verification of data controls, when it will come in the place, like verifying the data reduction or even encryption, it will be in the phase of design or actually in the phase of testing?
Great question. So when should the controls be done? And I guess that's, it should be done in both at design and testing. But I think, you know, in terms of when you should do the risk assessment and control development, you know, ideally at an epic level if you're using Agile, but you also might do, if you're using something like security and compliance check for every ticket, it's a compass, then you might want to also have that as a second place where you would just, if it's talking about personal information in the ticket, quickly do an assessment of whether you need to look at any risks or controls. But yeah, develop and then obviously test those controls.
Right, we'll have to wrap it up there. Thank you very much.